All right, guys, and welcome to today's webinar on the legal ramification of the COVID-19 bill in the isolation economy. Once again, thank you so much for joining us on a Tuesday. Our goal today is to talk to you guys about how it impacts the contractual obligation for businesses, which I think most of you in this session today are. Not to worry, you don't have to hear me again for today's session. Very lucky to have with us Kaka Wong partner, Jonathan Cole, joining us. I'll hand over his mic to him in a short while, but I thought just give you guys something as always. Once again, we have to always give this safe harbor statement. All of us try our best to make this relevant, but please do not hold us accountable. Please take your own independent advice before making decision. It should not be treated as an act of action of anything of this nature. So once again, please take your own legal advice if you need to take action from our sharing session. So once again, SGTech is a premier trade association. We look after the ICT sector in Singapore. We have more than 900 members, all the way from startups to the bigger companies itself. We're so blessed to be able to do this series of events with you. We're keeping up this isolation economy. There are three things. There'll be webinar, course, and some articles as well. Tomorrow, I want to point out to you guys that we're going to have another session about workplace wellness, how to manage employees, and how to adopt tech solution. You guys are welcome to so-called sign up for the session as well. Now, as always, I always implore you guys to finish and help us do our post-webinar survey. They are so important for us to collate data. To date, we have some very good responses, and we're actually making tweaks and adjustments to the webinar format and giving better suggestions to the relevant government agency because you guys are responding to the webinar. So please keep up this effort. We need you guys to help us dictate how we can better do this. All right. So please help us to do this so that we can better be able to give good recommendation. So and of course in this whole webinar, they'll be recorded and available offline. Anytime you have questions, please kindly just use the Q&A function to put it out there for us to be able to address them. We will start with 40 minutes of sharing, followed by the next 20 minutes of some Q&A related to the COVID-19 bill. So without further ado, I'm going to stop my own self from sharing. Stop share, here we go. And I'm going to pass it over to Jonathan to bring us through the COVID-19 bill. Jonathan, over to you.
Okay, thanks, Ivan. Let me see. Can you see the slides? Or I should get it expanded. Okay, sorry, are the slides in the full screen or wait, let me get full view, full screen. Okay, great. Okay, hey, good afternoon. My name is Jonathan. I'm a partner at Withers Carter Wong, and I practice in the area of IP transactions, advising companies in the F&B, retail, media, and technology sectors. So I usually advise them on their commercial transactions relating to their IP rights. I'm also an ExCo member of the Cloud and Big Data chapter of SGTech. So I'm really very pleased to be invited to conduct this webinar to help our SGTech members as well as others from SMEs who have signed up and to participate in this webinar. So I've been asked to share on this COVID-19 Temporary Measures Act 2020. This was just passed in Parliament last Tuesday, 7th April, and it was ascended to by the President also on the same day. So it really shows the urgency with which the government wants to introduce these measures into our system. Right. Now, let me just say by way of introduction that the COVID-19 Temporary Measures Act, there are actually 7 parts to it. But today I will only deal with part 2, which relates to the temporary relief granted to companies for their inability to perform their contractual obligations due to the COVID-19, all right? So the other parts which relate to bankruptcy, insolvency, conduct of annual general meetings, as well as remission of property tax and the well-known control orders will not be dealt with today. Those are the other parts of the Act. So today, we will just focus on part 2 on the temporary reliefs for inability to perform contractual obligations. So what I want to cover today in our agenda is to talk about the objective of the Act, the COVID-19 Temporary Measures Act. And if you look at the part 2, it says that the Act will apply specifically to scheduled contracts. So I will spend some time explaining what are scheduled contracts. And these scheduled contracts must apply within a prescribed period, the applicable period. So I will share with you what are the applicable period to which the scheduled contracts relate to that will fall under the Act. And if they fall under the Act, then what relief, the temporary relief that is granted under the Act will apply or are available to the parties to the scheduled contracts. So I'll spend some time talking about the relief and how to go about effecting the relief. But if there should be a dispute, notwithstanding the grant of the temporary relief, if there's a dispute between the two parties, then the Act provides that it can be resolved by assessors. So I will also share with you the process to which you have to go through in having the dispute resolved by an assessor. And the last part of the presentation, I want to talk about the action that should be taken during the suspension period. Bear in mind that this is a temporary relief applied within a prescribed period. So the prescribed period will come to an end. And when it comes to an end, all the obligations, the suspensions will resume. So you need to take certain action. So I will share with you what action you need to take during this period of time. So you have to stay to the end of this presentation to listen to what I have to share with you and the advice I want to give you about the action to be taken during the period of suspension. Okay, so these are the things I would want to cover during this afternoon's presentation. Okay, the objective of the Act. Why did the government introduce the COVID-19 Temporary Measures Act? And that's really because, as we've all experienced, and the fact that we are all working from home today, listening into this webinar from our home, it is because COVID-19 has impacted all sectors of the economy. Some businesses, especially the SMEs, are more badly affected than the others, like the larger corporations. COVID-19 has caused our government to, as you know, impose border restrictions. There are now no more movements between countries. They have also directed people to work from home, and they have shut down all non-essential services. So it has really caused a huge disruption to our economy, in particular the supply chain and the flow of labor. And sectors such as construction, food and beverage, tourism and events have actually been severely affected. So you'll see later on in my presentation that the Act deals with scheduled contracts that relate to companies working in these 5 specific sectors, all right? So the Act aims to provide temporary relief to companies from their contractual obligations so as to assist in preserving cash, all right? So one of the main aims is that companies affected by COVID-19 get to preserve cash flow, and they get to preserve their cash that they have now, so that when this whole outbreak is over or has come down, they have the cash to resume business, right? But the point about the Act is that it does not absolve or remove contractual obligations, but only suspends them for a prescribed period. Now, this is a very important point to note. It does not absolve or remove contractual obligations. So even though there's a suspension from your contractual obligations during this period of time, it doesn't mean that after this period, you go off scot-free. Your obligations will resume. And that is why you need to wait till the end when I'll share with you what actions you need to take to prepare yourselves when the prescribed period is over, right? So the suspension will be initially for 6 months, but may be extended for up to a year. And the Act specifically says that it will cease to apply, cease to have effect after 1 year, all right? So these are the parameters and the scope of the Act that you need to bear in mind, right? Now, going on to, as I mentioned, that the Act only applies to specific contracts, what they call scheduled contracts, within a applicable period. Now, I will now explain what are the scheduled contracts that fall under the Act, and then go on to the applicable period. Now, this is taken from the schedule of the Act, and it says specifically that scheduled contracts are the following. A and B relates to secured loans, okay, secured loans. But these are secured loans that are secured wholly or partially against commercial or industrial immovable property located in Singapore. So it is a loan that has for its collateral or a security commercial or immovable property. So that's to say commercial leases property, all right? Or it could be secured against plant, machinery, or fixed assets located in Singapore. So that is to say that they took out the loan, you took out the loan and you pledged your plant, your machinery, or your fixed assets. But it's not just any plant, machinery, or fixed assets. It must specifically be those used for manufacturing, production, or other business purposes, all right? So that is in para B2. It says plant, machinery, or fixed assets used for manufacturing, production, or other businesses, right? So that's the first category of scheduled contracts. The second category are performance bonds that are granted in relation to construction contracts or supply contracts. So if the contractor gave a performance bond to the developer, then this is a scheduled contract that falls under the Act. Now, then the third category are hired purchase agreements. And again, not all hired purchase agreements will fall under the Act. It is hired purchase agreements in relation to plant, machinery, fixed assets used for manufacturing, production, or other business purposes, or hire purchase of commercial vehicles, all right? So it's only specific to these hire purchase agreements. All right. Then I'll bunch the next two contracts, event contracts and tourism contracts as one category, because it really relates more to our tourism industry and events held in Singapore, our MICE in the industry. Then the fifth category is construction contracts, supply contracts, where it has been affected due to shortage of labor. As you know, the construction industry is very dependent on foreign labor, and as well as supply of materials. Usually we get most of our materials from Indonesia, Malaysia, and China. And as you know, the flow of goods from outside of Singapore into Singapore into Singapore has been severely restricted due to restrictions in air travel and sea transportation, right? Then lastly, the last category relates to lease of non-residential immovable property. So that relates to commercial leases, which I believe most of our participants in this webinar would be affected. If you work for a company and you have taken up a lease, then you are your lease agreement is one of the scheduled contracts that will come under the Act. All right. So the Act only applies to these scheduled contracts, and it applies to scheduled contracts made during this specific period. Okay. First of all, if you look at the graph in front of you, the bottom part says contracts entered into or renewed. Actually, it is on or before 24th of March, because that was the date that the MOH introduced safe distancing guidelines. All right. So scheduled contracts that were entered on or before 24th of March will come under the Act, and it must be scheduled contracts in relation to obligations to be performed on or after 1st February 2020. Then the temporary relief that are prescribed under the Act will apply to these obligations. So if your obligations fell before 1st February. So for instance, you had to pay your rent before 31st Jan 2020. The Act will not apply to that. So any contractual obligations that are to be performed prior to 1st February, you have to perform them. You are still contractually liable for them. The temporary relief under the Act will not cover you. Okay, it only applies to those contractual obligations that are to be performed on or after 1st February 2020. So as I mentioned earlier, the relief will initially be for 6 months, but the minister may shorten or extend this period depending on the COVID-19 situation. No one knows how long it will last. Some think it may actually last 1 year or even more, but any extension can be up to a year from commencement of the prescribed period. Now, the Act has not, the minister has not come up with the regulations as to when the actual prescribed period will start. When will the commencement date be? All right, and this will come up sometime end of this month, end of April. So we have to keep a lookout as to the regulations in relation to the temporary relief. So more information on that will come up later at the later part of this month. Okay, so to go on with my presentation, I need you to remember that all that we were going to talk about later on about the temporary relief applies to scheduled contracts that are described within the Act and apply to contracts made on or before 24th of March 2020 in relation to obligations that are to be performed on or after 1st February 2020. Okay. So with that backdrop, I will now go on to talk about the relief, the different types of relief given to the different types of scheduled contracts. Now, the first scheduled contract that I would like to talk about are secured loans. All right. So as I mentioned earlier, it relates to secured loans that have for its collaterals plants, machineries, fixed assets, as well as immovable property, right? So the bank cannot enforce the loan during this prescribed period and cannot claim upon the secured assets as repayment for the loan. Now, more details about the types of secured loans that fall under the scheduled contracts. To qualify as a scheduled contract, the secured loan must satisfy these following conditions, right? So not all secured loans that your company has taken will qualify unless it satisfies the following conditions. First of all, you must have taken a loan from a bank licensed under the Companies Act, the Banking Act, or a finance company licensed under the Finance Companies Act. So if you took a loan from some other lender that is not licensed under the Banking Act or the Finance Companies Act, then your loan is not covered under, will not be deemed a secured contract covered under the Act, right? Then secondly, you must be a borrower with no more than 100 million turnover in the last financial year as a group, okay? If you have a group of companies. But if you are just one company, then your last financial year's turnover should not exceed 100 million. But if you are part of a group, then you can take it collectively as a group that the financial, the turnover for the last financial year did not exceed 100 million. And you must be a company that has at least 30% of shares owned by Singapore citizens or permanent residents, okay? And as I mentioned earlier, the loan must have been secured whether wholly or partially against commercial, industrial, immovable property, plant, machinery, fixed assets located in Singapore used for the manufacturing, production, or other business purposes. So if you are concerned as to whether your secured loans will enjoy the temporary relief from enforcement by the banks, then you need to check through that it satisfies these conditions, okay? My colleague in the insolvency practice had have actually written a very insightful article called, the title is Navigating Loan Obligations Amidst the Singapore COVID-19 Temporary Measures Act 2020. And in it, my colleagues shared that not just elaborating on the conditions to be satisfied, but they also went on to deal with the temporary modifications to the insolvency regimes, the threshold limits for enforcing or taking out insolvency action, and the extension of the statutory demand period from 21 days to 6 months. And what MAS has given in terms of support measures for borrowers to allow them to defer repayment of the loan, but actually they may have to pay they may defer repayment of the principal amount, but they have to continue paying interest until 31st December 2020. So if you want to know more and you want to read up this article, I've put the link at the bottom, and you can go and click on the link or access the link, copy the link here, and go and access it from your browser and read up more about it. That will give you really more information on secured loans and what financial benefits that you can enjoy or apply for from the Monetary Authority of Singapore. Okay. All right, next we go on to construction and supply contracts. I'm not sure how many are contractors here, but as you know, in the building sector, there is always the main contractor and subcontractors. So even though you may not be the contractor in developing properties, but you may be supplying goods or services to the main contractor. So you may be a subcontractor, and these temporary relief in relation to construction contracts would be to your benefit, right? So as you know, construction is, as I mentioned earlier, very dependent on foreign labor and for materials to be imported from abroad, outside of Singapore. And so they are one of the hardest hit sectors due to the COVID-19 circuit breaker measures that the government has introduced. And as I mentioned, construction involves both the main con and subcontractors. One brick in the chain of the construction supply chain ecosystem would cause the whole entire construction development to stall. So what the Act has done is to extend the period for the construction of the property. As in construction contracts, it's common to have milestones to be completed, so as to know how soon you will complete each milestone to completion of the development, right? So the construction schedule will be suspended during this prescribed period, and during this period of suspension due to the non-performance, the developer cannot impose the liquidated damages against the contractor for the delay. Neither can they invoke the performance bond that the contractor may have given to the developer. So all these have been suspended during the prescribed period that the minister will announce in the regulations in relation to the temporary relief, right? So if you're in a construction industry, then you may be pleased to know that your obligations have been suspended during the prescribed period, and the developer cannot enforce it against you, right? Next, we go on to the hire purchase contracts, hire purchase agreements, and as I pointed out in the schedule to the Act, it relates to hire purchase of plant, machinery, fixed assets that are used specifically for manufacturing, production, and other business purposes. And it also includes commercial vehicles. And this is because why commercial vehicles have been included is because many tour operators, the coaches that ply between Singapore and KL, and many Grab drivers who rent cars using hire purchase schemes have been affected by the circuit breaker measures, and they would have purchased their vehicles on hire purchase. So what the act says, the temporary relief is that the lender cannot then repossess the commercial vehicles, and in relation to plants, machinery, or fixed assets, they cannot also repossess these assets as well. All right. So if you have hire purchase agreements, only if they relate to these specific assets, then will they apply. If your hire purchase agreements are in relation to, say, computers or photocopiers, and these are not essential or critical to your business, then it may not be covered under the Act. So, but if you want to make sure that they cover under the Act, because it says, it will not, because they're not fixed assets. So you may be vulnerable. You have to continue paying your repayment under the repayment installment schemes under your hire purchase agreements. All right. So that is in relation to relief for hire purchase agreements. Moving on now to relief for event and tourism related contracts. Now, event contracts means contracts for the provision of venue, the provision of accommodation, transport, entertainment, and catering for the purpose of organizing business meetings, conferences, exhibitions, trade shows, concerts, weddings, or sporting events. These are event contracts. Tourism-related contracts are contracts for bringing in tourists to come into Singapore, tour programs, and accommodation under hotel accommodation for tourists. These are tourism related contracts. What the Act says that in relation to these contracts is that the deposit that has been paid cannot be forfeited if you cannot proceed with the event or conduct the tours during the circuit breaker period, right? The deposit cannot be forfeited. If you look at most of these tourism and event related contracts, it will say that if you want to postpone the event, you must give at least 30 days notice. But as you know, a lot of the MOH guidelines came out and became effective within a few days of it coming out. Usually the government will give 2-3 days and say at 2359, the day after, it will come into effect. So there was very short notice, and many people were caught in this situation where they had organized events during this period and they had to cancel it because they can no longer come out and conduct the event. So if you are an event company listening in, you have to know that you cannot forfeit the deposit that was paid to you. But it does not also mean that you must automatically refund the deposit to the party that booked the event or booked the tour, right? You can negotiate with that party to postpone or cancel the booking. And you can refund the deposit. If they choose to cancel the booking, you can refund the deposit after deducting your reasonable expenses, okay? Notwithstanding that the cancellation says that, you must have given 30 days notice if you wanted to cancel it, right? So you can't forfeit the deposit, but this does not mean that the deposit will automatically be refunded to the affected party. You can negotiate to postpone the event till after the whole COVID-19 outbreak has subsided or is over, or you can choose to cancel, in which case then as an event company, you can deduct for expenses incurred and then refund the balance to the affected party. Okay, then now the last category concerns commercial and industrial property leases. Most companies, and I believe most of our participants in this webinar, if your company is leasing premises, this will apply to you, all right? And it says that during this prescribed period, your obligation to pay rent will be suspended. Okay, the landlord cannot terminate or evict you because you have not paid your rental during the prescribed period. Right? So, but you must also show that your inability to pay the rent was caused materially by the COVID-19 event. All right. If you are a big multinational company and you have huge reserves, you do have the resources to pay your rent, you cannot claim that just because you cannot open your shops now, or you cannot open for business, then you don't pay your rent. The inability to pay rent must be because it was caused to a material extent by COVID-19. Okay, so if there should be a dispute between the landlord and the affected party over the ability to pay rent, now this is one of those classic cases that you have to refer to the assessor, who will then determine whether you can or cannot pay the rent. And if you cannot pay the rent, then the temporary relief applies to you. Okay. So these are the, okay, so I've come to this part of my presentation where I've described the scheduled contracts that fall under the Act and the kind of temporary relief that the Act will give to those who are in scheduled contracts. Right. Now, the important point now is, what do you need to do? Okay, having known that, okay, you have the scheduled contracts and it falls within the prescribed period, what do you need to do next? Now, the Act says that you need to give notification for relief. Okay, so I'll set out here the procedure for relief. You need to give a notification for relief to the other party to the contract. And if there's a guarantor, like if you are in a construction contract and there's a performance bond, or you have given a guarantee, personal guarantee or corporate guarantee to the other party, you need to give the notification for relief to all these parties, okay, within the specified period. Now, the specified period is not known yet. As I mentioned, the minister will come up with regulations in relation to the temporary relief later this month. So when it comes out, you really need to quickly take a look at it, because it will set out what is the specified period in which you must give the notification for relief in order to enjoy the temporary relief. Okay. Now, when you give the notification to relief, you must state that your inability to perform the contract is materially caused by a COVID-19 event, right? Now, if the other party disagrees that non-performance was due to a COVID-19 event, then he can refer the matter to an assessor. Again, we do not know who the assessors are. The Ministry of Law is putting together a list of assessors, and I believe the list of assessors will come out at the same time as the regulations on the temporary relief. Okay, so you can refer the dispute to an assessor. Now, when you refer the dispute to the assessor, you have to make representations yourself. You cannot appoint lawyers to represent you before the assessor. So you will make your case before the assessor, your respective cases, and then the assessor will make his decision. And his decision will be final and will not be subject to appeal. And if an aggrieved party to the assessor's decision needs to enforce it against the other party, they can apply to court to enforce the assessor's decision, and the courts will enforce it in the same manner as a court judgment. So it is that serious. It has the force of law and can be enforced by the courts. Okay, and if you bring your case before assessor, each party must bear their own costs. All right. So that's a brief description of the procedure for notification of relief. And if there's a dispute over the relief, then it has to be brought before the assessor. Now, if the notification for relief is valid, whether because the other party accepts your notification or because the assessor has made a decision that the notification for relief is valid, then the other party cannot enforce the contract against the affected party. So it is a suspension of enforcement. The other party cannot, during the prescribed period, commence, or if he has already commenced legal proceedings, he cannot continue with the legal proceedings against the affected party or his guarantor. He cannot enforce any security over immovable property or movable property like fixed assets, plant and machinery that is used for his business. And he cannot also apply for a winding up, bankruptcy or judicial management order against the affected party. And he cannot terminate the scheduled contract. And this applies specifically to commercial property leases. If he tries to do that, then it is an offense under the Act. And if he's found guilty, he will be liable to a fine not exceeding $1,000. And this is what is stated in the Act. All right. So action to be taken. Before I go on to this slide, I want you to bear in mind that all that I've said, you can categorize them into two categories. One is, under the Act, there is suspension of performance. So if you are an affected party, your performance of your contractual obligations is suspended. So there is suspension of performance. And then as to the other party, there is suspension of enforcement. Okay, so in my last slide, I said that he cannot enforce the contract and he cannot take any of these measures. If not, he will be guilty of offense. So bear in mind these two things: suspension of performance and suspension of enforcement. Now, what I want to share with you now is the action to be taken regardless whether your contract in question is a scheduled contract or not. And this is because, bear in mind that the temporary relief is only temporary. It will only be suspended, your performance and the enforcement, for the prescribed period. At the end of the prescribed period, all the obligations will resume and you have to perform it. Okay? So you need to take action now. You cannot just say, hey, let's just stay home because the government says everyone must work from home, and don't do anything about your contract. You need to look into your contracts and see what you need to do about it. Do you need to terminate your contract? If you feel that you want to terminate, look at the termination clauses in your contract. Does it allow for unilateral termination by giving a notice period, and then you can terminate without cause? Or even if there's no termination clause that's to your benefit, you can also broach this subject with the other party and say, can we come to a mutual agreement to terminate the contract? Okay, so in law that's called discharge by agreement. So if you can negotiate and agree to a mutual agreement to terminate the contract, then that might be good for you. But of course, the other party may say, look, you still need to pay up whatever is due to him up to the date of termination. But this is a compromise that you need to make in order to be released and discharged from the agreement. So if you wish to terminate the contract, then go ahead, look into the termination clauses and discuss termination with the other party. But bear in mind, when you do this, it takes you out of the temporary relief, okay? So it's not a suspension of your obligations. You cannot claim on any of the relief given under the Act. You are stepping outside of the Act to terminate the contract based on its commercial terms. Or do you want to suspend the contract, okay? Independent of the temporary relief. You may want to suspend the contract due to and claim on a force majeure event because you are no longer able to perform your obligations due to a force majeure event. But if you want to claim on a force majeure event, okay, you must comply with the provisions regarding force majeure in the contract, right? So again, you have to look into the contract to see what it says about force majeure event. Okay, what is force majeure? Force majeure really can be defined to mean an unforeseen event which prevents someone from fulfilling his contractual obligations, right? So it is an unforeseen event that prevents you from fulfilling your contractual obligations. Now, then you have to look at the definition, because not all contracts define force majeure in the same way. It could define force majeure by identifying specific unforeseen events like acts of God, riots, union action, and so on. All right. Then you have to check if it spells out specifically the types of events. You have to check whether outbreaks, pandemics, or epidemics are covered or described in it. But even if it's not described specifically in there, then check whether there's an event called that's government orders or government actions. Because what we are affected is not so much about the COVID-19. We are not infected per se, but we are affected by COVID-19 as an event and by the government guidelines and the government regulations that have been imposed on us. So if the definition of force majeure event in your contract spells out specific events, check whether government regulations or government orders is described in the definition. Alternatively, the definition might be drafted widely to say that force majeure means any event that is unforeseen and beyond the control of the party, including but not limited to, then it usually spells out some specific examples of force majeure events. Okay, so it's very important to check the definition of force majeure event to see whether how you've been affected comes within the definition. Now, if you want to enforce the force majeure event, then usually the contract will spell out the procedure to that you need to follow. It may say that if you're affected by force majeure event, you need to notify the other party, and then it will trigger an automatic termination or suspension of the contract for the duration of the force majeure event, or it may just extend the contract by the duration of the suspension. So if you want to enforce the force majeure event clause, then see what it says about the procedure to invoke force majeure to suspend the contract. But in the same way as termination, if you go under force majeure event clause, you are stepping outside of the act. Then you are bound by the contractual provisions in relation to what it says about force majeure. Okay? If it says that it's terminated, good. Then you are no longer bound to continue with the contract. You are discharged. But if it says it's suspended for the duration, then thereafter either party may terminate it. Then you may want to then go on that basis and give notice of force majeure and suspend for the duration, and then elect to terminate without any consequences. But again, check with your lawyers to see what the provision says and how it affects you, right? Now, if you have not performed the contract at all, the contract has not started, you may cancel the contract under the Frustrated Contracts Act. What the Frustrated Contracts Act does is to say that those contracts that are impossible to perform or extremely difficult to perform will be cancelled, and the parties will be discharged from their obligations. And usually, you will rely on the Frustrated Contracts Act if there's no force majeure clause in there, or you have not started and the contract, you have not performed your obligations yet, but you are no longer able to perform because, let's say, you are dependent on supplies from abroad, and you are no longer able to receive your supplies, and so your ability to perform has been frustrated. Then you may want to claim upon the Frustrated Contracts Act and have it cancelled and terminated. But this has to be, both parties must agree that the Frustrated Contracts Act applies to the contract in question. So if that happens, then any advance payment that has been made on the contract because it's cancelled needs to be refunded. Any work done needs to be paid for or reimbursed. Okay. So that's cancellation under the Frustrated Contracts Act. Now, if you want to continue your contract, my advice to you is you can take the temporary relief measures. But as I mentioned earlier, the temporary relief is in relation to suspension of performance and suspension of enforcement. It will resume, your obligations and the right to enforce will resume after the prescribed period. So take this opportunity to negotiate variation to the terms of the contract, right? And what you must do then, if you want to vary the terms of your contract, is to enter into a supplemental agreement to agree on the amended or varied terms. You need to put it in writing and have it signed by both parties in order for the variation to be valid. Okay. So don't wait until the prescribed period is over and then start talking to the other party, because when the prescribed period is over, your obligation to perform and the right to enforce resumes, and then you're caught. Okay, you have no more opportunity to negotiate because the other party has the right to enforce against you once the prescribed period is over. Okay, so the take home for you is this. This is a suspension of performance and a suspension of enforcement during the prescribed period. The obligations will resume after expiry of the prescribed period. You need to take the opportunity to negotiate with your party to amend or vary the terms and enter into a supplemental agreement to record what has been agreed between the two parties as to how the contract is to be absorbed, to be varied or amended. Okay, so bear in mind, and this is my take-home message to you. Okay, the Act does not absolve or remove your contractual obligations; it only suspends them. It allows you time to work out a solution without the threat of legal proceedings. So take this opportunity to renegotiate the terms of your contract. Okay. So in summary, I have covered during this presentation what are the scheduled contracts covered under the Act, the applicable period for these scheduled contracts, and then the procedure for notification for relief. And if you want to dispute the relief, then you have to bring it before an assessor. And then my advice to you that you should take this time to negotiate and vary the terms of your contract. Okay, so that in summary is what I wanted to present to you in relation to the COVID-19 Temporary Measures Act in relation to Part 2, the temporary relief from contractual obligations during the prescribed period. So now we can take questions and from our participants, and Ivan will moderate this Q&A session. So I will hand this time over to Ivan to look through the questions, and it will be a question and answer session now.
Okay, I think guys, thank you so much to Jonathan for sharing all so much things. I think it is really very impactful. Just want to quickly, while I started the questions, right? I think just Jonathan, you mentioned about a website. So I just want to flash the Witters Kakao Wong website here for you guys to scan it, and in case you guys want the link to this site as well. So we have a few questions here. So let me just let's get started. I think most importantly, Jonathan, is there any relief for unsecured loans? If a loan is an unsecured loan type?
No, there's none. As I shared with you, not all secured loans are covered under the Act. It relates only to those secured loans that satisfies those three conditions that I shared with you. Okay, so unsecured loans definitely not covered. Secured loans, only those secured loans that satisfies those three conditions that I shared with you earlier on in my slides. And don't worry, SG Tech will make copies of my slides and send that out to you, so you can refer to those three conditions later on. So the answer to the questions, unsecured loan falls outside the Act.
All right, right. Thank you, Jonathan. Next question is this. Let's talk about events industry. Deposit for events that cannot be automatically forfeited. Are this just meant for events in Singapore? Does it apply to contracts signed in Singapore but are held overseas? For example, an overseas music festival.
Okay, good question, because I don't quite recall whether it talked about events outside of Singapore, but I believe it has to apply to events held in Singapore, and both contracting parties are located here in Singapore. So I believe it should be events held in Singapore. And if you look at the way that the Act works, because you have to give notification for relief, and then if there's a dispute, you go before an assessor, then quite likely it will apply only to events to be held in Singapore. But something to check up on, I will go through and see whether it's wide enough to cover events outside in Singapore, but I doubt so. Okay, but I'll check the Act and see whether it's wide enough to cover that.
Stanley, you can drop us an email at info@sgtech.org.sg for us to follow up with you on this if you need us to. All right, we have a bunch of other contracts related to contracting. Let's just answer the contracting one first. Jonathan, does scheduled contracts include IT contracts or any other form of contracts with the government of Singapore? Are they considered scheduled contracts?
Okay, so yeah, scheduled contracts include contracts made with the government, all right? So it doesn't matter that the other party is the government, it will still fall under scheduled contracts. Now, IT contracts, again, the Act does not specifically identify an IT contract as a scheduled contract, okay? So those categories of scheduled contracts are spelled out in the schedule to the Act. Again, you have to look back to my slides where I've highlighted which are the scheduled contracts. But if some of the scheduled contracts are performed by way of IT, as in by a mobile app or whatever, let's say it's a supply contract, and it's done by way of IT, then it could potentially fall within a scheduled contract. Or if it's an event that is done through using IT, then possibly. Okay, so gray areas, what we advise is you need to serve the notification for relief first. But if the other party disputes that it's a scheduled contract or whatever, then it goes to the assessor, and assessor can then make that decision for you. Or if you're not sure and you need advice first before you serve the notification for relief, then consult your lawyers, who will then look at your contract to see whether it falls within the definitions of scheduled contracts.
All right, thank you, Jonathan. A few bunch of rental questions here. Let's answer them. Okay, what if you enter a commercial lease before 1st February? Is this one subject to the COVID-19 this Act? Because the tenant have no idea that COVID-19 will be so bad, and just so happened that the lease was before 1st February.
Okay, need some clarification on that, because it applies to any contracts entered on or before 24th of March. So you may have entered the contract before 1st February. That's okay, but as long as is entered into on or before 24th March. But it only relates to contractual obligations, your rental payments that comes after 1st February. So I believe I did comment during my presentation, if your rental payments, you have not paid your rental payments for last year December or January this year, those are not covered under the Act. You have to pay them. It only applies to obligations that are to be performed on or after 1st February. Okay.
All right, thank you. Quick one. MNCs, are they covered under the Act for the commercial property rental as well? Larger companies?
Possibly they are covered, but as I mentioned, the inability to pay the rent must be because it was materially caused by the COVID-19 event. If you are MNC with huge reserves in your bank and you actually can pay your rent, then your inability to pay rent is not really caused, or well, actually I will then say you're not really unable to pay your rent. You can, because you do have a huge reserves in your bank. You have cash in the bank to pay. Then you should go ahead and pay. And right now circuit breaker measures is only until 4th of May. But of course, there's a lot of talk that it may be extended for a month. So rents are actually paid monthly in advance. So actually, if you have huge cash reserve, you're really only having to pay for 1 month rent or second month rent. And if you have the ability to pay, then you are not covered under the Act, because it is not a material cost that has prevented you from paying your rent.
All right. Next question. A few more left only. Don't worry, like 2 more. What do you think typically when an assessor look at to determine whether you can or cannot pay the rent?
Okay, so as the Act says, your inability must be due to a COVID-19 event. And this circuit breaker measure is a COVID-19 event, all right? So the assessor will have to ask, okay, satisfy itself that why are you not able to perform your contractual obligation? Okay, I just talk about it broadly, because your contractual obligation can include your contractual obligation to pay rent. So the assessor will ask, are you really unable to perform your contractual obligation? And the inability must be due primarily or materially to a COVID-19 event. So they will look at these two factors, conditions, to then make a decision, all right?
All right, and a bunch of sequential questions. So, will a tenant inability to pay rent attract interest and late payment charges since it's already in the contract already?
Yeah, I believe it will, because it says suspension during the prescribed period from paying rent. Oh, sorry. No, sorry. You are suspended from paying rent during the prescribed period. So if the prescribed period is 6 months, then during the 6-month period, you do not have to pay rent. But when the prescribed period expires, then all those obligations will resume. It will accrue, okay? So it will accrue, but they cannot charge late payment interest because your obligation to pay rent is suspended during the prescribed period. But your rental payment will accrue after the prescribed period. So it means that after 6 months, those 6 months of non-payment or rental will accrue to after the prescribed period.
So let's say
so this is how I understand the Act to be written.
So let's say if month rental is $1,000 and you stop paying for 6 months, you just pay $6,000. The landlord cannot put an interest possibly on the $6,000.
No.
Okay, that's great. Next one, what if a tenant become insolvent during the relief 6 months period?
Okay. So one of the relief is that you cannot take up insolvency action against the individual. So I mentioned about statutory demands and all that. Now, if you have an order of court and you want to enforce it against the defaulting party, one of the measures is to serve a statutory demand that they must pay up within 21 days. But the Act has extended that 21 days to 6 months. And if they don't pay up within the statutory demand period, then thereafter they can take up insolvency or bankruptcy proceedings. So the relief does cover all this. But if you are already in debt or insolvent and you have no ability to carry on as a business, then really I would suggest that you look into this, what you need to do to terminate this contract and then stop all the stop all your contractual obligations from running, and then negotiate a repayment. And actually, if you think about it, if you don't have cash nor assets, even if the landlord wants to enforce against you, they will not recover anything. So it's best that they work out a scheme that you can repay them something and then terminate the lease agreement. So that's my advice, that you look into this. All right.
Okay. And the last part of this one is the consequential loss insurance policy or other insurance policies such as keyman, personal accident. Does it apply during the circuit breaker, especially the consequential loss risk insurance policies?
Okay, I think that's outside the scope of the Act, and I'm not familiar with insurance policies. So that's something you firstly need to go back to your insurance agent to ask them for advice. And if you need further clarity, then speak to a lawyer who practices in this area and will be able to advise you what is the scope of the Act. All right?
All right, and I have a final question today. Intended advertising. What if you sign an advertising contract somewhere this year, but obviously now is not an appropriate time to run the ads, be it on MediaCorp or something else? What can you do? Does the COVID measure allows you to extend it to next year?
Okay, so for advertising contracts, that again falls outside the Act. So you need to go back to the media owner to negotiate. And again, very much like event contracts, you need to discuss whether you want to cancel the posting and get your refund, or you want to then suspend and run the ads after this whole prescribed period is over. So I suggest that you go and negotiate a variation to the terms of the contract with the media company.
All right.
So all these questions, I'll suggest, yes, if you want more answers or more comprehensive answers, drop us an email, send them to me. If I can answer, I'll help. But if not, some of my colleagues who practices in these various areas, whether it's insurance or rental of commercial properties, they will be in a better position, or even construction contracts. We have colleagues specializing in these areas, and we will be able to advise you on how to deal with them. Okay?
Thank you so much, Jonathan. I appreciate
it
so much. I think everyone definitely benefit from this. So without further ado, once again, thank you, Jonathan. Guys, this is the post-webinar industry survey. Once you close this, it will automatically be opened up. Just to remind you guys that tomorrow there will be another webinar on how to motivate your employees in the work from home era. So without further ado, thank you so much. We appreciate it, and have a good afternoon ahead. You can direct questions to us at info@sgtech.org.sg, or of course, if you can send it to Jonathan as well. Thank you, guys.
Okay, thanks. Bye.
Bye.
All the best. Keep safe.
Keep safe, everyone.